compensation credits, we often have to focus on things other than the fundamentals of workers' compensation subrogation. And before we get started, it's important to understand workers' compensation subrogation itself, its historical significance, its purposes, and why we have workers' compensation subrogation. And I take time to do this in each case because this is also a political ad. It's also a call to action on the part of anyone in the insurance industry to let them know that we do have a bit of a crisis out in the world of legislators, in the legislatures across the state, in Congress, as well as in the appellate courts, both appellate and Court of Appeals and Supreme Courts of the various states. And that is because I think a lot of people don't understand the historical significance of workers' compensation subrogation and the importance of protecting not only our right to recovery, but also the right to a future credit. And guess which gets hits first? I mean, quite often, plaintiffs' attorneys may not mind paying back a small lien, but do not want their client to be off of insurance company-paid medicals. They want to make sure that their client is taken care of. And so we go back to, if you let your mind's eye take you back to the turn of the last century, back during the Industrial Revolution, we had a rather interesting phenomenon occurring that manufacturing was increasing, factories, small businesses were proliferating, machines were coming into play, automating assembly line manufacturing, and there were no OSHA, state OSHA, federal OSHA, there were no safety guidelines. There was very little in the way of product. There was no product liability per se. All we had were common law negligence suits, and as a result, there were a lot of injuries. And of course, employees would get injured, and they would get injured during their employment, and oftentimes at the hand of the employer due to employer negligence, sometimes not. But it was commonplace in those days to have employees who were injured sue the employer and make a personal injury recovery from the employer. And over time, the burgeoning Industrial Revolution and businesses began to get some political clout, and they said, hey, this isn't really going to work if every time an employee slips and falls or tries to lift up a block engine or a heavy bag of seed and hurts his or her back, we have a lawsuit filed against us. There has to be something done. And back during the, those who have a penchant for history, you will think back to the late 1910s, the 1900s, the early 1900s, and you've got a progressive movement afoot in this country. And what naturally came to be was a system whereby employers would be immune from any lawsuits that their employees filed against them in exchange for a statutory and scheduled array of benefits for medical expenses that were related to the work-related injury, as well as indemnity benefits, a partial replenishment or replacement of lost wages. So the workers' compensation system was born, and as a matter of fact, in 1911, Wisconsin became the first state to enact a workers' compensation subrogation statute, which actually withstood appellate scrutiny and was held intact. New York was a year before us, but theirs was held unconstitutional. So we have some historical precedents here. And that worked great from the early 1900s, 1911 through the 1930s. Almost all states passed some form of workers' compensation laws which allowed the employer to be immune from suit. And this was the social pact. It was a covenant that we as society made with the employing public of the United States. And the reason for that pact is that if you can imagine opening up an insurance company back when Century was first founded, let's say that there weren't any workers' compensation laws, and one of the claims adjusters happened to slip and fall downstairs in the Century building. alleged that the lighting was inadequate, and sued Sentry to recover personal injury damages. Now, let's put aside for the moment whether that person's professional career was cut short at Sentry because they decided to sue their employer, but the fact is they could do it, and the employer had to engage counsel, involve themselves in litigation, and incur the cost of a third-party suit. Well, with workers' compensation now, we have the exclusive remedy, which says the employer is not going to be at fault, co-employees are not going to be able to be sued, but in exchange, we're going to make the employer completely responsible for all medical expenses, no matter how much they are, no matter how young the claimant is, no matter how many millions of dollars will be incurred. We're going to automatically make the employer responsible for those medical expenses. Well, as you can imagine, that's quite a burden to simply declare a public policy in the country to be that employers are going to now be responsible for injuries that occur even if it's not their own fault. And when workers' compensation benefits are recovered, the employer would be immune. Part of the problem became, though, that employees were now not able to sue their employer, but they were able to sue other third parties who were responsible. This gets to the nut of workers' compensation subrogation. Someone injured on the premises of a third party, someone injured in an automobile accident, someone injured by a defective product. These are all third-party targets that can be pursued not only by the employee, or pursued by the employee who also can now recover workers' compensation benefits. So for the longest time, employees were enjoying a heyday. They were able to recover workers' compensation benefits, and they were able to recover those same benefits again from the third-party tortfeasor. So not long afterwards, workers' compensation subrogation statutes began to proliferate. The idea here was that we don't want the employee to be compensated twice and obtain a double recovery for the medical expenses and lost wages which they would receive both from the workers' comp carrier and the third-party tortfeasor or its insurer. So they enacted subrogation statutes which essentially said if you're injured in the course and scope of employment and you receive benefits, the employer, or as many statutes say, the workers' compensation carrier is entitled to recover those benefits and be reimbursed for those benefits. And that worked great from the late 1920 all the way through about 1973, the early 1970s, when guess whose political clout came into prominence then? It was the trial lawyers. And the trial lawyers' prominence rose, not coincidentally, with the rise of product liability law, which really began to come into play in the early 1970s, late 1960s. Excuse me. So now you have a situation where the legislature started saying, okay, that's fine, workers' compensation carrier, you're entitled to recover, you're entitled to, or the worker is entitled to receive benefits, and also recover from the tortfeasor, but the workers' compensation carrier is entitled to be reimbursed. However, because for many, many years, the workers' compensation carrier was just sitting back and waiting for the plaintiff's attorney to do the heavy lifting, do the hard work, litigate the case, make a recovery, and then pay the carrier back, the attorneys finally said, enough's enough. We need to be able to recover a fee. So laws began to change, and workers' compensation claimants' attorneys were now able to recover a fee and a proportionate share of costs or expenses out of the workers' compensation carrier's lien. And in some states it's technically a lien, and in other states it's a right of reimbursement. And in other states it's just a true right of subrogation. It depends on the state. But generally the paradigms are all the same. So from the 1970s on, we now had a situation where plaintiffs' attorneys were able to recover the carrier's subrogation lien, pay it to them, but they also got paid for it, and things worked fine. But probably one of the issues that has been litigated most is the issue of the future credit. When and how, if the worker receives a nice recovery in a third-party tort case, and suddenly becomes wealthy because he's settled a multi-million-dollar case, the workers' compensation carrier should be allowed to take a holiday in the amount of the net recovery received by the worker from his tort case. And that essentially is the law in most states. Almost every state, with some exceptions, have the right to recover a future credit if and when the claimant makes a recovery from a third-party tortfeasor. They're not, all of these credits are not instituted the same. They're not calculated the same. They're not applied the same. And in fact, in some states, there is no right to a credit at all. Some states require that the credit be recovered up front. In other words, that the carrier receive not only its past lien, but the present value of its future payment obligations out of any third-party recovery. And but then again, the plaintiff's attorney attempt to take a fee out of those amounts. So workers' compensation subrogation had as its social benefits protecting the employer from being sued and allowing the employee the security of knowing that no matter whose fault it was, whether he was just stupid or whether she slipped and fell in an open and obvious situation, or whether the worker was injured as a result of the negligence of the employer, it's not going to matter. The worker is going to be taken care of medical expenses for life, indemnity benefits, partial wage replacement according to a statutory scale, and the employer, although they're on the hook for all of this medical, is entitled to receive this money back together with the future credit if there is a third-party recovery. Now, what I just want to mention briefly, there's an anti-subrogation movement about, because the story I've just told you, while it may seem a little bit unfair to employers, it does provide business for companies like you. So Century makes a business because of the workers' compensation scheme, but it also has this right to recover a future credit. And we've forgotten, judges have forgotten, that the employer is supposed to be immune from suit. Gradually, states, one by one, are starting to fall victim to the trial lawyers' propaganda about it not being fair that someone would be injured and wouldn't be able to recover from a tortfeasor. Let's say an employee is rear-ended by somebody with minimum limits and is seriously injured, and Century pays out a significant amount of money, and there is a recovery of the minimum limits. Well, the plaintiff's lawyers are saying, look, there's no reason why the insurance company, the rich insurance company, should recover back its money. The poor injured victim is the one who should get the money. And judges are starting to buy this because it's been a century, literally to this year, 1 century since we had our first workers' compensation laws passed. And they're beginning to forget the social benefits and the social pact that we made with employers. So not only is made whole coming into the picture, but in some states they're starting to pass legislation which outlaws workers' compensation subrogation. And the whole idea behind subrogation is it's supposed to help keep down premiums. Significant losses are erased because the party ultimately responsible for the injuries is held responsible, and the workers' compensation carrier receives back its past lien and gets a future credit. So it's as though the accident never happened except for the time and expense of adjusting the claim. So there is an anti-subrogation movement afoot. This is not only with Made Whole, but employer negligence now is starting to enter into the picture. States like California, Illinois, Minnesota, Arizona, Idaho, Kansas, Kentucky, Louisiana, New Mexico, New York, North Carolina, Utah, Texas are all beginning to pass laws which says, you know what, I think that if the employer is negligent, we should somehow prohibit its right to recover its past lien and its future credit. The only problem with that is nobody tried to prohibit the employer's liability for unlimited medical expenses where they weren't at fault. So the social pact is being forgotten. The other areas in which we are whittling away at the right of a workers' compensation carrier to recover benefits is in the elements of damages area, where some states are now saying, you know what, we're going to give the workers' compensation carrier its right to recover its lien and its future credit, but we're going to sort of limit it to the elements of damages recovered in the lawsuit that reflect the benefits that were paid by the carrier. And we know what those are: medical expenses, lost wages, with some exceptions, and because those make sense, and those are the basic elements of a personal injury case. So if any other damages are recovered, like pain and suffering, mental anguish, physical disablement, loss of enjoyment of life, loss of consortium, those sorts of things, we're not going to let the carrier recover its lien and its future credit out of those elements of damages. But again, we've forgotten the pact, we've forgotten the promise, the covenant, the social contract that we made 100 years ago when we said, you know, if you, the employer, are going to be responsible potentially for millions of dollars in medical, we're going to also make you immune. And while people are sort of lifting and forgetting the aspect of this covenant which allows the carrier to recover its money back off the top, which is still the law in most states, some states are forgetting about that. They are not forgetting about the part that says the carrier has to pay for all the medical and all the indemnity. So it is kind of a raw deal that we're seeing as a result of this anti-subrogation movement. Now, when we talk about workers' compensation subrogation, I want to make clear that this isn't exactly subrogation. And I know that may come as a shock, but the Campion versus Montgomery elevator case right here in Wisconsin makes clear that in Wisconsin, Section 10229 doesn't grant us a right of subrogation. It grants us an absolute right of reimbursement. So all of the anti-subrogation equitable defenses that other states are trying to raise up really should not have any play in workers' compensation subrogation if more states would have rulings like the one in Campion. You'll be happy to know, by the way, that workers' compensation subrogation is powerful in some states and not in others. Wisconsin is, without a doubt, the best state and has the strongest workers' compensation subrogation laws of any state in Section 10229. Arizona is probably a close second. Texas was up at the top. They've fallen a little bit with a little bit of tort reform thrown into the work comp mix. So we have a great state here in which to subrogate. Now, the purposes and functions generally of a credit, also known as an advance, also known as a vacation, and again, we're talking about plaintiff is injured on the job, receives benefits. Plaintiff sues tortfeasor who caused the accident that resulted in his injuries, recovers a bunch of money in that third-party case, and the carrier gets its lien back, and any amount of money that the plaintiff pockets, his net recovery in that lawsuit is generally considered to be a credit or an advance, and the carrier is not obligated to make any future benefit payments unless and until that credit is used up or exhausted. Now, this varies from state to state almost universally. Every state is different in how it applies its credits in advance, and that is why you receive the handout, which is in the form of the green notebook entitled Documenting Workers' Compensation Statutory Future Credits. It is a copyrighted publication. It was first created in 2009. It is the only one of its kind, and it contains not only a summary of credit law in each state, but how the credit is to be applied and, where applicable, what it is that you have to do in order to claim that credit, because we all know plaintiffs' attorneys are becoming more and more, we could say creative, and I'll actually go desperate, to squeeze money out for their clients, that they're now turning their sights and putting the crosshairs squarely on the backs of the workers' compensation carriers. So if you're not doing everything you're supposed to do to document your credit, I'm seeing that they are now going to be more frequently attacking your right to a future credit. And how do I know that? Because for the last 26 years, I've been a member of the American Association of the American Trial Lawyers Association, which is now the American Association for Justice. You can only be a member if you are a plaintiff's attorney But the trick here is that I can get in because I am actually a plaintiff's attorney, even though I represent insurance companies in subrogation matters. So I see the emails they're sending around, the propaganda, the checklists, the charts, the targeted attacks, and the cheat sheets on how to double check and make sure that workers' compensation carriers are truly documenting their credit. So the purpose and function of a credit, of course, is to allow the carrier to not have to pay any more benefits after a third-party recovery. And as I said, it's often more important than the lien, and it's extremely important to document carefully. A lot of times we see waivers of subrogation. I think this is an area in which our industry really should take a look, because for a $79 premium, somebody will pop a waiver of subrogation endorsement on a policy because it's required in a contract, and lo and behold, we're missing out on millions of dollars of recovery opportunity and future credits simply because some insured asked for it. And I don't think there's anything wrong with asking for it, but I think we ought to understand what we're giving up, and there ought to be some cost-benefit analysis done in the pricing and underwriting in that area. Also, I think what's happening is that contracts just automatically, as a knee-jerk reaction, include some type of requirement that any insurance contracts contain a waiver of subrogation, but they don't really understand why they're including it in there. And I don't think they realize that if the workers' compensation carrier doesn't get its lien repaid, they still have to pay the money. It still has to be paid to the employee. The only difference is that now the insurance industry isn't getting that money back. There's no effect on the risk experience mod, and in theory, the premiums for that particular employer who suffered the injury should stay high. So when you have a settlement of a third-party case, we're looking at issues of allocations of damages in those states in which credits are given only for certain elements of damages. We can see requirements that the damages be allocated, and plaintiffs, of course, are saying, well, this is entirely a settlement for pain and suffering, nothing for medical expenses and nothing for lost wages, therefore we don't owe you anything, Mr. Carrier. And in some cases, courts are sanctioning this sort of legalized theft. There's also the proper retention of the future credit and proper documentation, which must be discussed. The credits come in all shapes and sizes. It would take us 6 hours to go through a sampling of the different states, but Alabama, for example, follows what's known as the Miller formula, where you owe fees on future benefits. Alaska reduces the credit based on the percentage of employer negligence. In Connecticut, there is no credit. You have to recover all of your damages, past, present, and future, up front. Georgia, no credit. Louisiana, you get a credit for indemnity benefits only, limited to the recovery for lost future earning capacity in the third-party case. Massachusetts, you get a future credit based on a statutory formula. Montana, future credit was declared unconstitutional and their status is uncertain. In Ohio, the plaintiff is given the option of a trust account which reimburses the carrier as an alternative to a future credit. So many states allow the carrier to recover future benefits if it prosecutes the case and recovers attorney's fees. So this is one of the reasons for, and I think it was yesterday that we did the seminar on recognizing subrogation potential, and I perhaps talked even too long on the importance of prompt recognition and prompt action, immediate action on subrogation potential. Here's one of the many reasons why. If you are able to prosecute a third-party case as a work comp carrier where you have a significant reserve and there's a catastrophic loss, you not only can recover future benefits in your subrogation action, but you may also be able to recover attorney's fees, something that we do in Wisconsin quite regularly, where the statute allows us, and case law allows us to recover not only our lien, if we're the ones prosecuting the case, or if we're active in a case filed by the claimant's attorney, but we can also recover a portion of the plaintiff's attorney's fees. So it's sort of like it's reverse from what we see in a lot of other states. If we're active enough, we can make that claim, and we have a lot of plaintiffs' lawyers in this state who do not like us because we've gone in and taken a portion of their fees and paid it back to our client. So they have even more of a net recovery, a complete recovery. So calculating future credits, the typical calculation looks something like this. Let's say that we have a $30,000 lien, and a $120,000 third-party settlement. The attorney has a right in many states. Now, I'm going to use a generic calculation. Of course, in Wisconsin, we'll go through this in a minute, we have a statutory formula. But in most states, the plaintiff's attorney is allowed to take 1/3 off the top as an attorney's fee. Let's assume there's no costs. So you have an $80,000 net recovery that would go to the plaintiff. But wait a second, we have the right to a lien reimbursement. Our lien is reimbursed to us $30,000, and that leaves $50,000 net recovery for the worker. That $50,000 should be used as, and that should be equate to our future credit. So what happens is once we have a settlement, we want to document that credit based on the laws in the individual state, and that's why you have the green notebook. It gives you that law, gives you, in some cases, the forms, which we recommend using to notify the commission and all parties that there's a credit. And then, of course, you notify all the providers and say, Charlie claimant has received a nice recovery in a case. We are taking a future credit. From now on, send all of your bills to him at this address. And assuming we haven't waived the credit or there's no problem with the future credit, we've documented it correctly, that's what should happen. I'm going to mention just briefly that there's a potential trap here, and that has to do with the, again, the unintended consequences of good intentions of our federal government with the Medicare laws and the new regulations and the Secondary Payer Act. Medicare set-asides are now entering the arena and can be problematic whenever we settle a workers' compensation case in closed medical, whether it's by a dollar contract, whether it's by closing out by agreement, whether it's by adjudication, or whether it's by a future credit, as you see on the screen. Anytime that happens, Medicare is saying, hey, you guys may still be on the hook if somewhere down the road Medicare has to kick in. So this is not a seminar where we're going to talk about MSAs or the burgeoning bureaucracy of the Center for Medicare Services, but we do have a separate webinar which discusses those. So it's a little bit tricky, but what we're going to find in most workers' compensation subrogation cases where credits are involved is it's basically a horse race between the plaintiff's attorney and the workers' compensation carrier. We do not make good bedfellows. There's this story about the two lawyers walking in the woods. You may have heard this. They're walking along, hiking, both with their backpacks on, and a giant grizzly steps out in front of them. Immediately, one of the lawyers drops to the ground, takes off his knapsack, and takes off his hiking boots and starts to change into his tennis shoes. Meanwhile, the bear is starting to charge. The other lawyer looks at him and goes, what, are you crazy? Everyone knows you can't outrun a grizzly bear. And as the lawyer finishes tying his last sneaker and stands up, he goes, you idiot, don't you know the only thing I have to outrun is you? Well, that's essentially what we have in workers' compensation scenarios. It's going to be us versus the plaintiff's attorney, and that's from day one, from the very notice of claim to the very day that the settlement is funded. We're posturing, and it's a chess game between us and the plaintiff's attorney. Now, some of the tips that we have with regard to future credits, we're going to get into some specifics of different cases, but don't sign the release unless it preserves a future credit. We've all received workers' compensation recoveries in the past. In maybe 25% of the cases, the plaintiff's attorney or the defense attorney, depending on how the case is being handled, will send you a release, and it says, Century hereby releases plaintiff, defendant, defendant's insurer, and all other parties from any and all liability, blah, blah, blah. Please sign here, and here's your check for $7,000 for your comp lien. Well, that's all well and good, unless you happen to be in a state which has somehow interpreted that release to release any and all rights you have except the ones that are set forth in that document. And what the danger there is that in several states, it potentially puts you in the situation of waiving your future credit. So when the plaintiff has spent all his money on fast cars and vacations and jewels and whatever else, and they realize that, oh, I've got to have another medical procedure, and they're out of money, and they come to you and you say, no, we're not going to pay. We have a credit. Have you used all $50,000 for medicals? Well, no, I haven't. Well, okay, then go fish. Then they go back to their attorney and go, hey, what did you get me into? I don't have any money for medical. And the plaintiff's attorney, who may be thinking, wow, did I screw something up, begins to look and realizes that in that release you didn't preserve your right to a future credit. And so if we sign the release, and this is the same with mediation agreements, be careful. Don't sign any mediation agreement. Don't sign a release unless you scribble in there that Century is entitled to its statutory credit rights, and it's not waiving anything with regard to any rights to a future credit. Real simple. If anyone objects to it, the red flag should go up. They've got a plan. They're putting on their tennis shoes and intended to outrun you. So just think about those things. Be careful when settling work comp claims. There are some states, such as Iowa, that have a statute which for some strange reason says if you settle a contested claim, you waive your right to subrogation. Don't know why it says that, but it's there. Section 8535, settlement of a contested claim bars subrogation. So just be careful. Now, it's possible that when you settle a contested claim to specifically contract around that and say we do have a right of subrogation, but it's something you need to be on the lookout for. Be specific about past liens and future credits, totals, and outstanding bills. When you're in a mediation and the case is settling and they ask you what your lien is and you tell them it's $50,000 and they say, okay, we agree to pay you $50,000, we're settling, and then a week goes by, and then 2, and then 3, and then 5, and then 6, and you realize you haven't got your money yet, but you've gotten a lot of bills on your desk and you want to know what to do with them. And you realize that right before the mediation, the claimant had gone in and received additional treatment, had a shoulder surgery, had incurred some medical bills, and now you've got a $27,000 bill on your desk, and you call up the plaintiff's attorney and say, hey, our lien just went up, and they said, well, too bad, so sad, we've already agreed that we're paying you $50,000. When you settle cases, when you're involved in a mediation, make sure you're specific. Our lien is $50,000 today. If bills come in for services rendered prior to today that we don't know about, 2 days ago, 3 days ago, a week ago, we're going to send those bills to you and you're going to pay them. If you want us to pay them, we will, but then we're going to increase the amount of our lien and the amount of money you owe us will increase. Additionally, if this case isn't funded right away, if the settlement isn't funded for several weeks, any medical bills would come in, you have your choice. We'll be happy to pay the bills. We'll be happy to pay your continued indemnity benefit payments until your check comes in, but we're going to increase the lien correspondingly as we proceed. And then you also want to be sure to get documentation. You want to watch out for gerrymandering. That means parties getting together and agreeing that, you know what, there's a $50,000 lien on this case. We've got $50,000 limits. Why don't we pay all $50,000 to the wife for loss of consortium, pay 0 to the husband, and because the workers' compensation carrier in most states, not all, in most states is not subrogated to the right or to the any payment for loss of consortium to a spouse, they're not going to be able to recover their lien. So watching out for gerrymandering is key in these cases, and I see a lot of attempts of folks who think that you know, workers' compensation carriers are going to be pretty nonchalant about this and maybe not catch it. And lastly, always document your credit with the appropriate commission or the agency, and that's where the book that I've handed you comes into play. And we're going to go through a couple of states here just to give you some examples. We'll do Alabama first, and I'm going to get into Wisconsin. And I just want to show you some of the different ways in which credits are calculated. Now, if you do most of your work in Wisconsin, that's great. But understand that your Wisconsin employees don't always get injured in Wisconsin. They may get injured in Alabama. They may get injured in Texas or Hawaii or Alaska. And in those situations, it is always possible to apply the law of the state under which the benefits are paid to the lawsuit that is pending in Alabama or Texas or Alaska. We call it extraterritorial subrogation, but it's something that really behooves us to think about when the claim is young, because if we can make a decision as to which state's benefits we're going to pay a claim under, if we have any leeway on that at all, it may end up saving us a lot of money in the long run. but we're not here about extraterritorial subrogation, so let's talk about Alabama. In Alabama, it's somewhat complicated. For indemnity benefits, we are reimbursed. We simply have a right of reimbursement. For medical benefits, we only have a right of subrogation. So let's assume you have $1 million third-party recovery and a $100,000 workers' compensation lien, and let's say that means that the claimant's recovery is $900,000. Alabama follows something known as the Miller formula. And it had to do with a case called Miller, which, by the way, is the longest cited case in American history. If those of you who have a copy of our work comp book, if you turn to the Alabama chapter, you'll see some of the citations to the Miller case. It went up on appeal, then back down, then up on appeal, then up to the Supreme Court, back to the Court of Appeals, back to the trial court, up to the Court of Appeals, back to the Supreme Court. So the string citation is like half a page long. It's almost comical. But this Miller case said basically that for credit purposes only, the court is going to allocate damages. And we're going to, the formula, and it's a complicated formula, we're going to calculate the net recovery, which in our scenario is the gross recovery less the lien, $900,000 in the example I gave. We then divide the net recovery by the value of the third-party case. All right, big red flag. Already we have a very subjective factor entered into this equation, the value of the third-party case. Who do you think is going to value this case the highest, you or the attorney representing the worker? So that's a point of contention and an area in which we may have to litigate quickly or have a hearing to determine the value of the third-party case, because it's always worth trillions whenever the Miller formula is at issue. Then we multiply the actual future benefits by this fraction, and we get the gross future medical expense credit. Don't blame me, folks. I didn't make it this complicated. Life can be a lot simpler. Then we reduce this amount by the carrier's pro rata share of attorney's fees. And for that, a separate formula under a case called Fitch is used. And we come up with the product of the net future medical expense credit. And then that number, and that's a different formula, by the way, that number is then put on a document known as the WC-4 and filed with the Workers' Compensation Commission in Alabama, and we have our future credit. So it's a long, long road to get to something that should be quite simple. In Wisconsin, life's a little easier, and we have a lot more advantageous opportunities. Let's assume a $900,000 case. The plaintiff's attorney settles. He gets the formula in Wisconsin is that attorney's fees and costs, and let's say there's just a straight attorney's fee, no cost for math purposes. That leaves a $600,000 recovery. Out of that, 1/3 goes to the worker off the top, free and clear of any credit, and that leaves a $400,000 net recovery, out of which our past lien is reimbursed completely. And note that in Wisconsin, unlike most states, we do not owe a portion of our lien for attorney's fees. We do not owe a portion of our lien for costs and expenses and expert fees and things of that nature. So this leaves $150,000, which is a statutory credit. It's a credit for any payments which benefit the carrier. Medical management fees, medical bill audit fees, because the whole issue of workers' compensation subrogation and what we're entitled to recover is overshadowed by the question of, well, what exactly is a benefit? What do we get to include in the lien? And we often default into the, well, it's just the medical and the indemnity benefits that we paid. And we forget about the thousands, tens, hundreds of thousands, in some cases, of dollars spent for medical management fees, medical bill audit fees, which in Wisconsin we have great arguments for including in our lien, and in other states we don't have as many. Now, this example you see on the screen is an injury case. If it's a death case, we have something in Wisconsin known as the Brewer methodology. This is in death cases in which the court must allocate benefits among beneficiaries and non-beneficiaries. It is the only weak link to Wisconsin subrogation. And it basically means that if there is a plaintiff in a death case, a beneficiary of the deceased who recovers, who is not a workers' compensation beneficiary, then money he receives, we should not be entitled to recover or include in this formula for our workers' compensation lien or the future credit. But the good news is the court is going to determine that, not some trial lawyer somewhere trying to gerrymander the settlement so as to cheat you out of your money. So this is the formula. Whether we prosecute the case, whether the plaintiff prosecutes the case without us, no one can deviate from this formula except for an agreement. This is true whether we prosecute it or the plaintiff prosecutes it. When you get to structured settlements, there's some additional rules, but generally Wisconsin is pretty straightforward. Now we go to the Sunshine State down in Florida. And Florida has approached things a little differently. They do protect the workers' compensation lien, but they've kind of eaten or drank the plaintiff's attorney's Kool-Aid a little bit, and they follow something called the Manfredo formula. This says that, and this applies anytime the plaintiff recovers less than the full damages in a case. And how often do you think that is? Practically always. So in almost every case, the plaintiff's attorneys, and I've got several Manfredo cases in litigation right now, because it applies when there is no full recovery claimed by the plaintiff. And how often do they say, oh, I've gotten more than I'm entitled to? But you take the ratio of the net settlement, that's what the plaintiff recovers, less attorney's fees and costs, to the full value of the case. Up go the red flags again. Now we have a subjective element, a subjective factor entered into the equation. We now have to litigate this. And those four words, full value of the case, is what is litigated in Florida. Plaintiff says it's $3 million. I say it's 1.2. The difference in terms of what the carrier is going to get back for its lien and future credit could be as much as $100,000. So it is significant. And the carrier then has to reduce its future benefits by this percentage. So it's a pro rata reduction of future benefits into the future that takes place in Florida rather than a full stoppage or vacation, and you have to file a specific form unless there's court approval at the district court level. And again, this is all documented in the green notebook that we've handed to you. In Georgia, the statute reads, the insurer's recovery under this section shall be limited to the recovery of the amount of benefits paid under this chapter. Those four words are the key, which mean that unless benefits are paid under Georgia law, you will not have a right of subrogation in Georgia. So anytime you have any of your workers injured in Georgia, I would urge you to try any way, shape, manner, and form you can to pay Georgia benefits, whether they're favorable or less favorable, because if there's any subrogation potential whatsoever, unless the benefits are paid under Georgia law, you will not have a right of subrogation when that case settles or you receive a verdict in a Georgia court. And basically, there is no future credit. So what does this mean? I mean, it's ridiculous, but you basically, if you have control of litigation or a say in the litigation, one of the things we do is we string things out. I don't agree to deadlines. I will order another deposition and move it 2 years down the road if I can, because what I want is I want us to pay as much of our obligation as possible, as much of our reserves as possible before this case resolves, so that we get as much back. And guess what? The plaintiff is trying to do exactly the opposite. So we go back to my story about the bear. Funny thing about Georgia, they don't know what's going on. It's a very volatile state. In 1920, there was no subrogation allowed. In 1922, there was subrogation allowed. In 1972, there was no subrogation allowed. In 1992, there was subrogation allowed. They can't figure out what they want to do. But we have to file an intervention in Georgia. Anytime there's a suit in Georgia, you must intervene or you cannot complain about the allocation and you cannot file a separate action. So some things to worry about there. We get to the fun state of Illinois. And this is a crazy state in which we are limited to our past lien and future liability because in Illinois, it's one of the few states where the employer can be liable for contribution. If the employer is at fault, and guess what? They always are. If you ask the plaintiff's attorneys, and those are the ones who are going to file the complaint, they will include the employer as a defendant for contribution, but you are limited to the past lien and future liability only, known as the Kentucky cap. Now, this Kentucky cap can be waived and is increasingly waived in stock contracts and form contracts that are signed, but if you have a Kentucky cap, you don't have to worry about the negligence of the employer. If the Kentucky cap is waived, then you have to worry about whether or not your employer, and that means you under coverage B to some extent to the limit of its coverage and any other insurance that the employer may have, may then be on the hook to pay some portion of that verdict. Practically speaking, the defendant pays the verdict and seeks contribution from the employer. There's a big question as to whether or not fresh money is owed by the defendant. And in terms of the future credit, generally what happens is you pay 75% of whatever future benefits you owe. I'm sorry, you get a 75% credit, so you pay 25% of any future benefits you owe under Illinois law if, as, and when those benefits are incurred. And unless, of course, you do some sort of a dollar contract that wraps everything up. But Illinois is an extremely confusing case. If you go to our website, there are some articles, under articles that go through in depth and explain this confusing state. So you'll want to look at that. But the bottom line is there's a case, Lefevre versus Chemlite, which says if you waive your lien and your future credit, you can get out from having to pay contribution. Now that case was a case in which there were no future benefits. The comp case had been closed, so there's some question as to whether or not your liability exceeds that. In Indiana, this is a state in which the carrier has 1 year after the statute of limitations to file suit. It's good to know that because if you're looking at a claim and you go, oh no, the 2-year statute is ran, we don't have any subrogation rights. Well, it's just the opposite. It's really party time because now you have the only rights to go against the third party. And the statute reads, when there is a third-party settlement, the liability of the carrier to pay future compensation terminates. But a new case recently came out that says, nah, that's not really what it means. There is no credit when the recovery is made before an award and the recovery is less than the anticipated benefits. Again, it's a confusing state because the statute says something different than the case law says, and then there's going to be an issue about whenever there is recovery of less than the benefits that were anticipated. In Iowa, the carrier must intervene in Iowa or file a notice of lien or it's going to lose its lien. If the plaintiff brings an action, there is no provision for a credit when the worker prosecutes the case. However, the carrier is allowed to take a credit when the carrier prosecutes the case. Go back to yesterday's seminar when I talked about the importance of prompt action. This is another example of why I'm saying that, because without that prompt action, we will not be entitled to a credit. But warning, you must file it at minimum of notice of lien, preferably an intervention. And secondly, again, as I talked about earlier, if you settle a contested work comp claim, your subrogation rights may be barred. So we want to talk generally when we're talking about, excuse me one sec. Okay, sorry, still recovering from the hockey game. Credits rights vary greatly among the states. If you go to the state of California, and the state of California is a state I could spend the entire hour on, too often carriers waive their liens to get a credit due to them because the credit is so important. It's not necessary to waive a lien to get a future credit, but it just goes to show how significant future credits are to some carriers. In California, it's important to note that there is no credit in medical malpractice cases. Tort reform is taking care of that. But generally, when the third-party case settles, you have 3 choices. You have the choice of either recovering your lien and entering a compromise and release of the comp claim, or you can recover your past lien in a stipulated credit amount, in which case the lien is usually a little larger, or the plaintiff can contest everything, and the trial court has to decide whether the employer was negligent in the trial, that percentage of negligence, and then decides the lien reimbursement and the credit. And essentially what you have in California is you have a threshold of employer negligence that has to be met, a dollar figure, above and beyond which you do not recover anything. For example, if you have 20% employer negligence found by the court and a $1 million recovery, that means the employer is responsible for $200,000 or 20% of that $1 million judgment. Unless and until your lien exceeds $200,000, you don't get any recovery. And if your lien and your credit does not exceed the $200,000, then you don't get a lien or a credit, and it's called the employer threshold or the credit threshold. So you have to be aware that these are thresholds that have to be met. And there's, you have different opportunities in California. So I think, like I said, California is another state that that probably we could spend the entire webinar on. So the big question, though, is in California whether to intervene or not intervene or file a notice of lien. I just want to mention, and I'm hitting on California because there are some important things. You don't have to intervene in a case in California, but in California, the plaintiff has the right to settle around you. Plaintiff and defendant can get into a smoke-filled room, conspire, and agree to settle without paying your lien, and then they can go away. The only difference is you now have the right to prosecute the remainder of the case against the defendant. And when are they going to do that? When are they going to settle around you? Why? They're going to do it when they know you aren't paying attention, when you've only filed a notice of lien. So our strategy in California cases is we intervene. We are legitimately active where we think we may have to try the case. If it's a complex case, we have our own experts because the plaintiff will take his experts and go home. We have our own experts, our own evidence, and if the plaintiff settles, we're ready to go to trial because they will usually settle right on the eve of trial or the morning of trial, and the judge will say, okay, carrier, proceed with the case. And they don't want to hear, well, I'm not ready to try the case. So you have to make a decision. In some smaller cases, it may be just a notice of lien is adequate. Medium-sized cases, you want to intervene and maybe not be horribly active, but enough that the plaintiffs think, that the defendants think you might be willing to try the case against them. And in larger cases, you want to be active and intervene. It's important with regard to future credits to know the law. You have to be specific in mediations. Know what has to be filed. Be very specific in your agreements about what you're entitled to. And when in doubt, always document your credit. It doesn't hurt to scribble it on a document, to have your lawyer included in a release. We are entitled to our statutory credit because more and more often, and as I said, I've seen this with the American Association of Justice emails. They're emailing around to the tens of thousands of trial lawyers out there. Here's a trick you can try to try and screw the carrier out of its credit. Know when your subrogation counsel involvement will save or increase the recovery. I think as an industry we try to avoid lawyers, and that's not always a bad thing, but there are many situations where involving the lawyer will increase your recovery and perhaps protect you from being totally shut out of any recovery. And those are cases that perhaps ought to be discussed with subrogation counsel so that you are making the right decision. It's good to be penny wise, but not to be pound foolish. Be aware of problem states. We've discussed some of them. Illinois and Minnesota are examples of two states where the employer can actually be brought in for contribution. Illinois is worse because in Illinois they've completely forgot the social contract we made 100 years ago. They're allowing the employer to be brought in for significant dollars. California we discussed, and again, there are articles on Illinois and California, two of the biggest problem states, on our website under articles. You can just search under the name of the state and those articles will come up. And those are really good to read if you have any cases out there. And if you have counsel out in California, if you're not using us, please feel free to copy that article and send it out to them because they will make, I guarantee you that most counsel aren't familiar with the nuances of how that law works and what the variables are. Then be aware of a waiver of a past lien to close out pending compensation claims. In a lot of insurance companies, the claims department is eager to waive a lien in order to get rid of their credit because it makes them look good. But meanwhile, the subrogation folks are going, hey, wait, we want to make a recovery. So there are happy mediums, and I think that this is where subrogation counsel can be consulted with in order to help you make the right decisions. You don't want to be stepping over dollars to pick up dimes, and I see that happening all too often. The bottom line, I would say, is active participation. In most cases, it's going to benefit you, and it actually will benefit the plaintiff. One of the things that workers' compensation carriers, subrogation clients don't think about is not all lawyers out there are good lawyers. People hire lawyers by just looking at the TV guide or watching, in Desperate Housewives, they'll have a commercial in which some local lawyer will pop on the screen and say, "We'll save you money." Well, these are not qualified lawyers to handle a lot of complicated cases, and if your subrogation rights are riding on, and your hopes are riding on this guy's talent, a lot of times it may behoove you to be active just to make sure that there's a future credit. So that concludes the 1-hour hastily gone through a webinar on workers' compensation subrogation credits. Most of the answers to questions you'll have, I think you'll find in the Documenting Workers' Compensation Statutory Future Credit Handbook, which is, I think it's green, I'm not sure. Mine's green, but it's pretty lengthy and contains a lot of the forms which we have recommended be used to notify parties of your credit, because the more people you notify, the better off you are. Again, thank you very much. If you have any questions, you could forward those questions to me by email, and I'll be happy to handle them. I've enjoyed the Strong CE Week. I think more insurance companies ought to do this. It always makes me very proud when I see clients taking the time to educate their claims folks on this very, very difficult and fast-moving and changing subject of insurance subrogation. Thank you very much. Bye.